Ready, start. Seldom do I entertain a writ petition under Article 226 of the Constitution of India when the petitioner has an effective statutory remedy unless there are compelling reasons. I am, however, constrained to interfere with the decision of the Regional Transport Authority since all the statutory provisions have been thrown to the wind. This is particularly so since the parties are not at variance on facts and only the interpretation of the statutory provisions applicable remains to be considered. The second respondent was operating a stage carrier service with his vehicle KL 533221 on the route Harijan Colony on the strength of a regular permit. The second respondent applied for clearance certificate, obviously to transfer the vehicle to another keeping the regular permit under suspended admission. This was followed by WP in bracket C number 23071 oblique 2013 on the file of this court, wherein a clearance certificate was directed to be issued by Exhibit P1 judgment dated 12/9/2013. The validity of the regular permit was to expire on WP in bracket C number 24250 oblique 2015, 15 for 2014, and hence the second respondent had applied for its renewal on 23 2014 well in advance. The second respondent did not pursue the application for renewal of the regular permit for quite a long time since he had no vehicle at his disposal for the operation of the service. It was only on 21 to 2015 did the second respondent make available another vehicle KL53H oblique 1186 of the for the purpose of the renewal of the regular permit. The second respondent simultaneously put in an application for replacing the vehicle KL533221 with a later model vehicle KL53H oblique 11862 to operate service on the route. The Regional Transport Authority, by one stroke in its decision on 21/5/2015 in bracket as item number 105 in Exhibit P3 proceedings bracket close, allowed both the renewal and replacement. This is challenged by the petitioner in this writ petition, contending that there has been a flagrant violation of the provisions of law. The petitioner claims to be a staged carriage vehicle operation and has sought a temporary permit to operate service on the route earlier served by the second respondent. I heard Mr. Stalin P. Davis, advocate on behalf of the petitioner, Srimati K. A. Sangeeta, the government pleader, and Mr. Sanjeev Kapoor K. Gopal, W.P. in bracket C number 24250/2015, advocate on behalf of the second respondent. Rule 172 of the Kerala Motor Vehicles Rule 1989 in bracket the rules for short deal with the renewal of permit, and Rule 172 oblique 2 thereof which is relevant is extracted hereunder. Application for renewal of permit shall be in form PRA and shall be accompanied by permit where the motor vehicle is subject to hire purchase, lease or hypothecation agreement, the certificate or communication, or as the case may be, the declaration referred to in subsection 8 of the section 51 of the Act. Emphasis applied. Thus, every application for renewal of permit shall be in form PRA, which is mandatory, and entry number 2 in the form is the registration mark of the vehicle covered by the permit. No application for renewal of permit would lie without the registration mark of the vehicle to be covered by the permit, and the same is evident by a plain reading of the rules. The second respondent did not have at his disposal a vehicle, leave alone a registration mark on 23/2014 on which the date he applied for renewal of the permit. Stop.